and showing us what it was like to drive on that street and where that 3-hour break was, where the phone was turned off or put on airplane mode. How is that useful as a former prosecutor? Does that affect how you're going to present the case, knowing that this information is out there?
Absolutely. Cell site evidence is a part of many criminal trials right now. And I mean, it's just a treasure trove of evidence for prosecutors, both in terms of search history, obviously call logs to and from text messages, and that cell site evidence that can really put a defendant really within feet of where they are. Now, obviously, we don't have that in this case. So the prosecution, you see it's laid out in that affidavit in support of the search warrant. They are trying to give some sort of explanation. Obviously, this is a PhD student in criminal justice. He understands cell site evidence. Maybe he's been watching court TV a lot. And there is a specific reason why his cell phone wasn't pinging off any towers near the scene of the murders. So this is going to be something important. Prosecutors got to get out ahead of this in opening. And of course, we know that the defense is going to slam this because they're going to argue that this shows that he wasn't at the scene of the crime.
Exactly. I was just going to say, these are the little details that defense attorneys are going to take and say, guess what, jury? Reasonable doubt. If you can't answer why he was not, how he could have done that not at the scene of the crime where his phone wasn't, you know, then that's reasonable doubt. I think it's a good argument that can be made in this case. And in terms of the hearing on Thursday, we know it's called a status hearing in this particular case. What might you expect to happen at that kind of hearing?
Actually, I don't expect a whole lot to happen. We know that this is the type of case that is likely going to go to trial. Why? Because if you're the prosecutor, look, I mean, Idaho's a death penalty state. This is a death penalty type case, and you can't give any type of deal. So, and on the flip side, we have a pretty sophisticated defendant as far as murder defendants go, and I don't expect him to say anything. I expect the judge to just go through some procedural matters, and that's it. This is the type of case that we should probably prepare to go to trial, given the facts and circumstances here. I can't see there being any type of resolution. And again, I'm not saying I don't think that Kohberger did it, but it's not a slam dunk murder case as far as the evidence goes. I mean, you would normally expect a gruesome murder, 4 people killed, for there to be more forensic evidence, blood, DNA. We have one, DNA identifier in the knife sheath that's linked to Kohberger's dad, but really as far as forensic evidence that puts him at the scene of the crime, that's really it. And we're relying on a kind of a fuzzy eyewitness statement. We talked about the cell site evidence, and other than that, just the identification of his car. So prosecutors are going to probably need a bit more evidence to get over that hump, and especially if they're going to get a death sentence here.
And for to your point, the blood of the crime scene, the blood on him, where's that? The knife, we don't know where the murder weapon is yet at this point in time. And I also have to say, we had a former attorney general from Idaho join us who said if he insists on a speedy trial, we could be looking at a trial within 6 months. So if that's going to happen, it could be 6 months to the next year that we actually see the trial. Neama, you're going to stay with us because coming up next,